Exactly. Let's go down to 21, juridical constructs. There's one thing I want to go through here, and then I'm going to start pulling up some other things about the UCC and show you why you've been talking to me about Freedom Club USA, about Dorian Group, these people who were doing bonds, bills of exchange. What I'm telling you is they don't have standing to state a claim, which means they don't have standing to do what they're doing. They don't have a claim. They don't have an administrative remedy. They don't have a claim because they're doing it against the state that they belong to. Okay. This is about establishing a juridical construct and how it's done. Now, this one was something Arthur wrote, and it just blew my mind because this had to do with Civil Rule 9A relative to Civil Rules, the Rules of Civil Procedure 12H3. Wouldn't it be nice if it were so easy to make a mere suggestion that to promulgate 12H3 and obtain super sponte the imperative shown based on the absolute free choice of tacit recourse for failure to rebut the specific negative averment in Rule 9A? The only way for me to explain this is to go to Rule 9A. So at this point, what I'm going to do, Ray, I think we don't need anything else. I'm going to pull up an internet browser, and we're going to get into specific. We've gone through what the right of self-determination is, and also the rights and duties of individuals, why people don't have a right to file these claims. And if they don't know yet what's going to happen to them, then just consider what happened to Dorian. They went to jail for 25, I think it was 25 years the sentence is.
22.
Right. And now you're telling me that there's a possibility they're going to come back with even more charges. So they don't have standing to state a claim. But I'm going to actually just go, let's go to Title 18. I'm going to show you exactly what they're violating. Exactly. So we'll talk about Rule 9A and Rule 12H3 in just a second. Okay, well, I'm just going to go through this real quick. I'm going to read it to you, Ray. I'm under Title 18. Part 1, which is crimes. We go down to Chapter 19, which is conspiracy. Oh, nope, I'm wrong. We go down to 47, fraud and false statements. Because this is what they're doing. This is what it is. It's fraud and a false statement because it's violating treaties. It's violating copyright. You're a tortfeasor. You trespass across someone else's intellectual property right. And you're making a demand. And the demand appears under Title 18, Section 1003. It's a demand against the United... This is under Title 18 1003 because I've seen this charge on people before who've done bills of exchange trying to do whatever they were trying to do. One guy was finally told years ago, I can't remember his name, it was Ben something, it was in South Carolina. What they told him, you know, what you've done is you tried to tap the stock of the United States. What's that? What's the stock of the United States? Who's the stockholder? Of course, I already knew because I understood the posterity. They're the stockholders. Anyway, whoever knowingly and fraudulently demands or endeavors to obtain any sum or share of the public stocks of the United States or any part there transferred, assigned, or sold or conveyed, or have any annuity, dividend, pension, wage, gratuity, or other debt due from the United States, or any part thereof received or paid by virtue of false or forged or counterfeited power of attorney, authority, or instrument, shall be fined or imprisoned under this section for not more than 5 years, or both. The point is that this is the charge. This is whether they actually put it there or not. Now, if they don't get them on this one, they're going to get them for mail fraud, bank fraud, all these other kind of things. And the mail fraud one's hard to overcome because the post office is powerful. All right, let me go back real quick. I want to go into OAS.org in just a second to solidify what I just read out of 18 Section 1003. We'll go down to Title 28 real quick, though, and talk about what was just mentioned under juridical constructs, how under 9A, this has to do with pleadings and special matters, capacity. It is not necessary to aver the standing or capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, except to the extent required to show the jurisdiction of the court. This is a waiver. They're saying it's not necessary to aver your capacity. Well, why would you want to waive your standing if you have standing, right? Because that's what's going to show the extent of the jurisdiction of the court. When a party desires to raise an issue of the legal existence of any party or capacity of a party, i.e. the standing of that party to sue or be sued, the party desiring to raise the issue shall do so by specific negative averment. Now, I've seen people do tons of specific negative averments, and this is what I missed for years until I met with Arthur, and this was the first question I had for him on juridical constructs. I wanted to know, what does this mean right here? Which shall include the supporting particulars as are peculiarly within the pleader's knowledge. I said, what does this word particulars mean? Because obviously I don't know what it means. because they've ignored everything in terms of what I consider to be a particular, i.e. I'm sovereign, I'm an American. The particulars they're talking about is your pledge to something else, which says that you have assumed your position among the powers of the earth, and you've pledged to support different declarations, and you're going to quit usurping and trespassing across their private intellectual property, period. Okay, now once you do that, once that's done, then we go to 12H3. 12H3, and that's what he mentioned in juridical constructs, that wouldn't it be nice if we could do this? And it is nice because I've seen it work, and I've seen it done, and I've seen them honor it. That's what I'm telling you, Ray. They're doing it right, and they give honor where honor is due. It says that waiver or preservation of a certain defense whenever it appears by suggestion of the parties or otherwise that the court lacks jurisdiction of the subject matter, the court shall dismiss the action. Without those particulars, they're not dismissing because they own it, they control it, they have the copyright, and if you've trespassed it, they're going to take those actions. I want to go back real quick. Two places I have to go. One is into the UCC. There's a code that people ignore completely in the UCC because they think they have a right somewhere. If they don't understand it by now, they don't have that right because they don't have standing. So if you don't have it, you got nothing. I have seen this stuff work against individuals, from individual to individual, and from individuals to corporation, and from corporation to corporation. But under international law, you cannot file that claim against the state you belong to, period. That's it. All right, under UCC 5116, this is the linchpin to the entire UCC, is the choice of law and forum. The liability of an issuer, nominated party, or advisor for an action or omission is governed by the law of the jurisdiction chosen by an agreement in the form of a record. Okay, you file a UCC 1 in the state of Georgia. Didn't you just choose your law and your form as Georgia, Ray? Okay, so now Georgia owns your document. That's your law form. You've submitted to that form. You don't have your own state. You haven't set up your own UCC wherein you're going to file and own your own documents, your own commercial instruments. The point of this one is, when you look at treaties and you look at these records, the jurisdiction of the law chosen need not bear any relation to the transaction. I'm going to go down to C here and read this real quick. Except as otherwise provided in this subsection, the liability of an issuer, nominated party, or advisor is governed by the rules of practice. If this article would govern the liability of an issuer under subsection A or B, or if the relevant undertaking incorporates rules of custom and practice, or if there is a conflict between this article and those rules apply to the undertaking, those rules govern except to the extent of any conflict with the non-variable provisions specific to section 103C. Non-variable provisions, what is that? This is where Arthur learned, and he taught me, that we can do, once we come out, we can do, that's what treaties are. They're a variation of agreement, and they become non-variable when you have those variations of agreement in place by agreement with the Society of Nations. This is about peace again. You're setting up these variations of agreement so that you know how you're going to treat and treaty with one another. And under 103C, it says, with the exception of this subsection, it says the effect of this article may be varied by agreement. There's your variation of agreement right there. It may be varied by agreement, provided you got standing to vary the agreement and they agree to it. And they also can agree by acquiescence, by the way, as long as you know how that works and how it's done. Because the acquiescence, according to their conventions, which we read earlier, can take up to 6 or 7 months. But it doesn't mean that anyone's going to respond. It just means that they acknowledge your adherence, and they've got your document. So they've now agreed. Whether they signed it or not is irrelevant. You gave them notice, and when they didn't disagree, they then agreed. This was so critical in finding this in the UCC, I can't even tell you.